In the legal section of the written submission to committee, Mason Hayes and Curran outlined legal amendments which could be considered to address the major policy issues flagged by the other speakers, as well as a series of standalone legal issues which were apparent from our review of the bill, and which are capable, in our view, of being addressed in subsequent drafting of the bill. I'll now turn briefly to a number of heads of the bill which the committee may view as relevant to our appearance. Head 5 introduces discretionary reporting of suspected charity law offences. We envisage that problems could arise if the regulator is not obligated to share information with An Garda Síochána, where information comes to the regulator which indicates a criminal act or a breach of law. We suggest that a positive obligation should be imposed on the charities regulator to share information with the appropriate authorities where a suspected offence has occurred. Head 7. This proposed amendment inserts a legal obligation that a charity shall not amend its constitution without the prior approval of the charities regulator. We're concerned that this provision is not proportionate, as it requires the prior approval of the charities regulator to any change to a charity's constitution, however minor or inconsequential. In our view, it would be unworkable in practice and reflects a significant extension of the regulator's statutory powers in terms of how charities define themselves. Head 8 grants the charities regulator powers to make changes to the information on the charity register without consultation with the charitable organisation in question. As it stands, this head would not provide the charity trustees with an opportunity to comment on, object to, or agree to the changes to the register. We believe that the regulator should engage with charity trustees in relation to any change and afford them the opportunity to make the change themselves. Head 9 streamlines the process of removing charities from the register and establishes the power of the charities regulator rather than the High Court as the first adjudicator. Removal from the register is an extraordinarily serious sanction with very far-reaching consequences. Charities are only permitted to operate in Ireland if they are on the register. This head removes several important steps in deregistering a charity and could lead to a sudden shutdown of public services, immediate loss of jobs, and the suspension of all financial transactions and board status for a charity which suffers a deregistration. Head 23 introduces an obligation for charity trustees to notify the charities regulator as soon as practicable where there are reasonable grounds to believe a significant event has occurred or is likely to occur. We have some concerns in relation to the definition proposed for significant event. This head creates a circumstance where trustees could be retrospectively held accountable for not reporting something which is later determined by the regulator to be deemed significant. We believe this will place a disproportionate burden on charity trustees who must decide in the abstract whether a potential set of circumstances qualify as a serious incident. This may become one of several administrative burdens placed on the regulator, as concerned boards may decide to report on all manner of possible significant events in their need to comply, thus overwhelming the regulator's capacity. Head 24 relates to directions arising from an inspector's report and a new offence of failure to comply with a direction. This head gives the regulator significant discretionary power, including power to deregister a charity without any input or submission from the charity. We recommend that this provision be amended to facilitate engagement by the charities regulator with the charity prior to any decision in relation to removal. Head 29 addresses payments made to charity trustees other than for fulfilling their role as trustees. Certain charities have provisions in their constitution that permit or oblige, for instance, the CEO to be a charity trustee. Additionally, the proposal to require advance approval to any arrangement between a charity trustee or a person connected to that trustee relies on a very broad and potentially inappropriate definition. There will be circumstances in which it's good governance practice and the best outcome for a charity to enter into an arrangement with a trustee. Many of these arrangements are already in place and no provision is made for this reality in the bill. This is a lengthy section and we have a series of concerns about it which are set out in our written submission.
One of the most important things that jumped out to me, Head 9, Section 43, and again, Head 8, Section 40, and it's about this ability to delist a charity. So there's no sense of a graduated response in here. It's like we go straight to a nuclear deterrent. I know if you're removed from the register as a charity, essentially that's it. Essentially, you're going to close the curtains and go home. I don't see the steps leading up to that. I don't see within the bill sufficient need to engage with the charities before that deterrent is put in place. And then I don't see an appeals process whereby if a charity feels that they were unfairly dealt with, that they'd have some sort of recourse. So I think that's one of the central things that jumped out at me from your submissions. And also certainly this idea, the requirement to disclose information on a significant event, which is crystal ball gazing from anybody who's involved in a charity. How you're supposed to see, of course, significant events should be identified and they should be acted on, and we should have a situation where charities feel like they can go to their regulator and say, listen, we think there's a problem coming down the line, can you help us with it? But as currently constituted, it's like you're supposed to look into a crystal ball and by God, if you miss something, then you're on the hook for it. And I don't know if that's going to help charities to view the regulator as a resource that can help them and something that they can be relied upon. So I know that there's many more issues that I could draw on from your written submission, but if we start with those, and if I can invite you to comment on those specific provisions.
I would merely say, as a charity lawyer coming at this strictly from the legal perspective, that the removal from the register as currently drafted in the legislation provides no reasons are required, I should say, for a removal. And I think from a legislative robustness perspective, at the very least, to have a requirement for reasons inserted would be very helpful. I think that quite a forensic look at the long list currently, where removal can be invoked as a sanction. I think, to be honest, we will clearly see some offences which are disproportionate to the sanction of removal. We have an offence here of refusing to or neglecting to ask the charities regulator, may you make a change to your name? Many charities make changes to their name each year. At the moment, as drafted, our legislation provides for an automatic removal from the register for a charity that fails to seek approval for its name change. So it is my view, it is our view at Mason, Hayes and Curran, that the full list of events which can result in removal ought to be scrutinised, that only events which are proportionate to the sanction should be included at all, and certainly that a process backed up by an obligation to provide for good reasons should be instituted. If I could say one word on the significant events. Efforts have been made in the bill to define significant events, but three quite general definitions are given. Loss of property is one, even broader, something that may have a reputational risk for the charity is another. So we had some concerns about the broad nature of those definitions. Work could, I'm sure, be done to precise in more detail what type of an event actually is a significant event. And having conducted some comparative analysis with similar legislative regimes in charity law, we did notice that generally in other jurisdictions, the obligation to report a significant event is put into guidance from the regulator. And from a policy perspective, one might think that guidance from the regulator, which can be very easily amended over time, might be a more appropriate home for this obligation of the reporting of a significant event rather than primary legislation, which is so difficult to amend. And my final comment on the significant events is that the other jurisdictions are not retrospective. They are not requiring charity trustees to make a compulsory report on something that might in the future occur. I just think from a legal certainty perspective that is really very difficult and certainly quite chilling. Thank you.
If you're on a board of a charity, you would be terrified to open your mouth at a board meeting, because then it would be minuted, and then now you're obligated, no matter what the concern was that you raised. So what will happen is people won't raise things at a board level.
Or there will be an absolute flood, Deputy, of incident reporting will become the norm, and every charity in a month might say, oh, potential for a reputational risk here, let's send in our report. And we have to think of the integrity of processes within our regulator, which does such great work with limited resources.
This is the one that I find a little bit difficult, and that's around the head 29, which is to, we're talking about personally connected people. And I think, for me, it's a difficult one, because I can understand where it's coming from. Because, what you don't want is, obviously, you don't want charities, in some ways, like there's nepotism going around, or you're giving contracts to people who, it's not maybe as open and transparent as it possibly is. So I think we just need to tease that one a little bit, because I am still a little bit, fuzzy about that one. So I suppose that's the only one that I would look at, because I think a lot of stuff has been covered so far. Thanks.
Yeah, Ms. Murphy.
Thank you very much. So head 29 is related to section 89 of the bill. There is already a section 89 of the Charities Act on the statute book, but because this is a very vexed issue, Deputy, it was never enacted. It was never commenced. And I believe it's something that legislator, the regulator, advisors, policy experts have all given a lot of thought to. The new section 89 runs to, I think, some 20 subsections, so it's really trying to deal with an awful lot. I agree with you that this is a tricky matter in governance terms, and as somebody mentioned at the outset, in a forum like this, we invariably focus on the thorny issues, and that is not to say that the concepts and the principles of Section 89 are anything but quite correct and good and positive. In terms of the way that the section has been drafted, we did collectively have some worries. Our first worry centres around the fact that, as currently presented, the new Section 89 requires an advanced approval for any circumstance in which someone who is on the board is being paid by the charity, even where they're being paid not for sitting as a trustee, but for something else that they do for the charity. So there is what we were terming a clean slate approach taken, where the section is written as if no charity in the country has anyone on the board who is also doing something else for that charity. And therefore, the way it's written says, if you ever would wish this to be the case in your charity, first you have to go to the regulator and you have to seek advance permission. So I think that is the biggest issue, because across the third level education sector, across healthcare, and in many other sectors, we have people on the boards of charities today who also are employees of those charities, work within the charities, or who have some class of an arrangement. We always use the fictional example of maybe they own the photocopying company that leases the photocopier to the person. So you have two categories of arrangement existing already. First category, very straightforward, you're the CEO and you're also on the board. And in some cases, legislation requires that, in particular in education. It's premised on there being both executive and non-executive board members. So take one of those institutions, the Charities Act, as it is intended, comes in and that's not permitted anymore. You have to go for advance approval to the regulator. So the clean slate, the imagining that this doesn't exist at all, is a drafting problem here. This exists, and we cannot have large charitable organisations who are stymied on day one of the legislation, and the CEO doesn't know, are they allowed to come in? But there's another piece of legislation that says they must come into the board. So that's quite a big worry. In other subsections, then we have some other issues that we think are suboptimal. The notion of a link, you mentioned it yourself, Deputy, the definition of a personal connection is very broad, okay? So I think we all understand why generally good governance practice might suggest that you don't give the contract for the big whatever expenditure you have in a year to the man on your left on the board. You know, that's very well understood. But our charities in large measure run on a shoestring in this country, and there are circumstances where the gentleman on the left on the board is a builder and is saying, listen, I'm just going to do it for you for cost, and everyone else is saying, can't do it for cost, it's going to be 3 times that quote. If there is a building which is falling down, following my fictional example, and the charity desperately needs for its vulnerable service users to rebuild, and it has to wait for advanced approval, that's fine if there can be an advanced approval process with the regulator which is swift in those sorts of circumstances, but the regulator's resources are limited, and routine applications of this nature in other areas can take 3 months, 6 months, and so you can see the problem that can cause. And the final worry we had about this section was that definition of personal connection is particularly broad, and if you had somebody sitting on your board who also had another business and they had a business partner who was in some other field entirely, you could find that you can't actually procure a service for the charity based on the definition as it is at the moment. But I regard those as more technical. The principal concern that we had was the issue of a slam dunk date when all of a sudden one finds that charities all around the country are in breach of the law.
And just from your experience of reviewing, I suppose this is more to Ms Murphy than anyone else, but by all means come in on it. Just from your review of the experience in other jurisdictions, and I know you've reviewed it from a legislative approach, but in terms of a cultural approach, have you come across an example of a regulator where it has been more a cooperative, a more supporting role that the regulator has played rather than a policing and enforcement role? And is there a good example or template there that we could use? Because sadly we don't have any good example here in this country, and regulation has been operated in this jurisdiction in terms of fear right across the board in all of the sectors that I've had experience of over the years. Thank you.
Charity regulation in Ireland is reasonably young and new. Historically, those of us involved in charities going back a long time will remember the revenue commissioners used to set some rules, but a proper, fulsome statutory framework for the regulation of charities only came in with the Charities Act 2009, which was actually only brought into law on the 16th of October 2014. So we have about 8 years of charity regulation, just shy of the 8-year mark here. Our regulator, I believe, would have leaned on the older legislative regimes in common law jurisdictions, and one we often go to is the Scottish regulator called OSCAR, Office of the Scottish Charities Regulator. In terms of a friendly and supportive and meaningful regulatory framework which is of assistance to charities in keeping themselves going, we think that the presence of guidance is very useful. In addition to primary legislation, it is my view that primary legislation can only go so far in tackling what you're speaking about, Cahir, like approach. You know, you will never nail culture and approach in a piece of primary legislation. You can go an awful lot further in terms of the establishment of a supportive framework by soft law instruments such as guidance, such as something that would say on a website, you can come to us as a charity. I think Oscar, the Scottish regulator, does well on that front. The Charity Commission of England and Wales equally is a good benchmark and has a more established regime. Our own regulator has gone a huge way in the last 2 or 3 years in the production of guidance to help trustees. But I would venture to suggest that whether or not a given regulator operates as a policeman or whether or not a given regulator operates as a supportive oversight body will probably not come down to the words on the page of the Act. Naturally, we adopt Deputy Donnelly's transparency, fair and proportionate approach in a review of the legislation. We certainly, in my view, should take out things that are clearly disproportionate and clearly unreasonable. But with the best will in the world, in the development of a legislative framework, one must rely on the regulator and the regulator's office then to take that legislation and interpret it in a fair and supportive way, rather than taking that legislation and saying, aha, we now have 3 powers and coming down hard on every minor issue which comes on their desk. That has to be led by the regulator's office, in my view.